Chapter 7 bankruptcy here in the state of Florida, which is a straight liquidation bankruptcy, and it used to have been the most common type bankruptcy, but maybe not so much anymore.
Well, it is. It's still the majority of cases filed, but in 2005, they changed the law to impose what they call a means test. What it really is an income test. So it takes a look at the family size of the household, and if you make above a certain amount and you have consumer debts, then you may not be eligible for a straight Chapter 7. You may have to file a Chapter 13, which is a reorganization of your debts over a period of 5 years.
If you file a Chapter 7 here in Florida, you get to keep your home, as I understand it.
That is an interesting issue because while Article 10, Section 4A of the Florida Constitution says yes, there are some limitations now since the changing of the code in 2005 that sort of define what equity you're allowed to keep if you file within certain time periods. Without going into that a little bit further, we don't have another hour to talk about all the types of situations that can arise where you might find yourself in trouble if you filed a bankruptcy without some legal guidance and keeping your home.
If you've owned your home for a number of years, you might very well qualify to keep it even in bankruptcy.
That's correct. Right. And it's half an acre inside the city limits and up to 160 acres in the county.
And what about IRAs, retirement accounts, 401ks?
Those are pretty much protected under federal statute, state law, and Supreme Court decisions.
All right, very good. Hey, folks, my guest today is attorney Jim Monroe.